A couple of things I've had in discussion in that break, I've jotted down. One of them is keeping that courage, keeping your confidence up when you are thrown a difficult question or slammed down by the bench that you have. And it's very important not to let it spiral downwards and to make it shut you up and be really quiet and feel like you can't. An objection you might make, but if it doesn't work, what do you do? All these sorts of things. It's very, very important not to get your head down, to keep that courage flowing, and everyone will have their own way of approaching it, I guess, but it's very important to try and develop a bit of a thick skin in that way. It's easy for me to say after more than 10 years at the bar, but we do this in our lives generally, and it's just tapping back into those qualities, tapping back into those situations. It might be that you deal with a difficult family member frequently. It doesn't mean that you don't ever talk to them again, generally. It means that you approach them in a different way. You might think, oh, it's because of this, that. Don't think that judges are perfect. They're not. They might think they are sometimes, but everybody has their own foibles and their own particular way of dealing with things. Sometimes they've had a bad day. Sometimes they're still having a bad day and you're copying it. And it's about knowing how to deal with that in the best way possible, remaining professional, keeping dignified, and not getting your head down. Another issue that was raised is when the judge throws you something. Oh, what you are trying to say is this, Ms. Serpell. Okay. Careful. You're about to make a decision. Are they really helping you? Is it an olive branch or is it a poisoned chalice? So don't just guess. If you think, fantastic, I didn't know the answer to that, this is obviously the answer. The judge is telling me, there, look, they've got to be pretty bright. Don't do that. Be careful. If you don't know, don't guess. You might need an adjournment to work out the answer to that. It might be that you address it after lunch and being able to research it a bit more. Many an advocate, a new advocate, goes down because they thought they were getting something helpful, but it wasn't. Or something that was helpful, they didn't pick up on. Be observant, be mindful, take notes, keep a pen and some paper always handy. It might be that you have prepared your examination in chief or your cross-examination so thoroughly that you have all your questions written out. Be careful of writing all your questions out. Be careful of just working from a list. Great to have the support, and the key word here is all. It's not all of your questions. It shouldn't be all of your questions. Why not? Because if they are, it means you're probably not listening to the answer. We had this point raised earlier. In fact, I think it was the first one raised by Barry, about listening. So I ask you a question. I don't shut down and turn away to look at my next question. I need to work out what you're saying in relation to my question, if it's cross-examination or chief. Have you answered the question sufficiently, if it's chief? Am I getting that story out? And I'll come back to this shortly. If it's in cross, are you dodging the question? Are you actually giving the answer that I'm seeking? Etc., etc. You're listening actively. And so there'll be follow-up questions that you'll probably need to ask. And if you're not listening, you're only doing not even probably half the job. So great to have the preparation, but don't think it ends there. And don't distract yourself. You've got to train yourself. The first thing you want to do when you're on your feet and you're not used to it is sit down as quickly as possible. You want to get through it and then go home. But you've got to resist that and push through. The other issue was about humour. Okay, everyone's a bit tense, it's a difficult case, or you're there and it's early, you want to relax. In my experience, mostly my early experience when I was an associate to Justice Marshall, a couple of years there, and it's really good to see how humour was employed those who did it well and those who did it poorly. And in my experience, not just from that time now, but also my time at the bar, the best humour, if you are going to engage in it, and I say be wary, don't just jump in straight away in this regard, is self-deprecating humour. You don't want to have the judge as the butt of your joke, bad move, for obvious reasons. You don't want your instructor either to be the brunt of your joke, or your client. It's fraught, isn't it? So really the only sensible approach is to make yourself the butt of your own joke, but even there you've got to be careful. Don't make it so much of a joke about yourself that you diminish yourself in the eyes of the bench, the jury, the other side, your client, even yourself. So it's delicate, and you might start with a very little bit and then see how it goes. But don't make a habit of it. Don't distract yourself while being, missing your chance to have a career in comedy, and transferring it to one when you're actually on your feet in a courtroom. So we've gone through a lot of the aspects already in these notes that I've given you. I want to talk about case theory. It's the last point on the first page. We go over to the second page and we talk about working backwards, developing your final submissions first. Why? Because it's what you're going to need to argue, and then everything else taps into that. So you work out what you have to argue in order to succeed, to either win your case or to defend it successfully. And from knowing that, then that informs everything that you'll be asking in examination in chief and everything that you're going to be asking in cross-examination. So you work backwards. What do we do in chief, in examination in chief? What we do is to get the story from our witnesses. And that's important. It's a real distinction. It's getting the story told by them, not just to give you a rest, not even to give you a rest. Good examination in chief, it's undervalued, chief, but good examination in chief is very deftly done. It looks like you're not really doing anything when you're doing it well. I like to think of it when I'm in examination in chief, and it's not so much of a role play, it's just gives you a visual idea, like a sheepdog. You're herding the witness a little bit this way, a little bit that way. They've got a story to tell. You know what points need to come out in that story in order to successfully get the necessary points for your case if it's going to succeed. And you are stopping them here when they're going a little bit off too much down that way. It might be all very interesting. It might be colourful. It might be all sorts of things. But if it's not relevant and necessary, be careful how far you let your witness stray. So as the sheepdog, you're holding your witness there. Okay, well, thank you. I'll hold you there for a moment. Now, and then you go back. So how do we ask the questions? What sort of questions are we allowed to ask? Most of you will know that in examination in chief, you can't suggest the answer. Okay, so how do we not suggest the answer? Some people get so caught up in this, they think everything is likely to suggest some possible answer, so how could you possibly even say anything? Right? But it's not too hard. You look here, I've given you a few tips, top of page 2. You are getting them to, can you describe, Victor, for me, please, your time in Hong Kong? So they say, but you said Hong Kong. Okay, that's permitted. But I'm not telling him, suggesting to him how his time in Hong Kong was. So I might say, Victor, can you please describe your time to me in Hong Kong? And Victor will say some things. If it was cross-examination, you spent time in Hong Kong, didn't you, Victor? Yes. That was back in 1973. You were there for 8 years, weren't you? And I'm putting these things to him. I'm doing the talking. I'm telling the story. It's my story to tell, and he's simply agreeing with it. It's very different. So the way I prompt in examination in chief, well, okay, what happened next? You're interested. You're developing a rapport with your witness, and you're letting them tell the story in a way that is filling in the necessary parts. I'll hold you there. Can you now tell us about this? What did you observe about that? It's all the descriptive words. It's all the, okay, it might get into if it's about what Victor was wearing today. How did you dress this morning? Did you dress yourself? What time did you get dressed? Where were you when you got dressed? Are they your clothes you're wearing? Whose clothes are they? All of this is fine for Chief. If it's cross-examination, you're wearing a suit today. It's a woolen suit, isn't it? It's grey. You're wearing a lavender shirt. It's a buttoned shirt. You also have braces on. They're paisley, aren't they? This sort of thing. I just saw those. I hadn't noticed that before. So you can see the difference. It seems easy, but it can be quite hard. And to know the words you can use is quite helpful when you're starting up. To know the words you shouldn't use is very important. You don't want, and it's bad for your confidence, and it's bad for your professionalism. It doesn't really give your client a lot of confidence in you either if you keep getting slammed down for leading a witness in chief. Just remember when you want to slam somebody for leading, make sure it is in cross-examination, because in cross-examination, of course, you're allowed to lead. And I've often had people jump up on the other side, perhaps a bit green, and complain that you're leading the witness when you're actually in cross-examination. Well, the difference is, in cross-examination, that's what you're supposed to do. Not just what you can do, that's what you should do. You should do it all the time. You shouldn't do anything else except lead. It doesn't sound great. It's not the way we normally talk. It's not the normal way of engaging in conversation or having a discussion. It's very one-sided. And in cross-examination, that's exactly what you should be doing. I imagine, and I tell people when I'm teaching this subject, I want you to imagine that the witness has a ring through their nose. And on that ring is attached an incredibly short lead, so that you would have to hold the lead about there. And you don't let that lead get any longer than that. You are leading them completely the whole time. As soon as you stop doing that, they're off the leash. They can say things that you didn't want them to say, and this is not the place for that. It's very strict. If you're doing cross-examination well, it doesn't have to smell or look like that, but the words you choose, the questions that you pose, are designed for really just the witness saying yes, yes, or no occasionally if that's the way it's structured, but they are not to be giving a whole range of different thoughts about things. It's a bit trickier when you get expert witnesses, but the same principle really applies. The most important thing is that you remember never to let ever the witness in cross-examination explain their answer. So see the picture of Pauline Hanson with a big cross in it. It's never, please explain, in cross-examination. If you do that, ouch, you're gonna cop it. And if you don't, you've really dodged a bullet. So the words you can use in cross to help you there: did, were, was. You heard the sort of questions that I asked Victor, and you're telling them. What about re-examination? That's a little bit tricky sometimes, isn't it? When do you ask questions in re-examination? Well, you're only permitted to ask questions in re-examination if they, in the first instance, arise from something that was asked in cross-examination. So from there, that doesn't mean you should. You still have to be mindful, you still have to be wary. Is it going to advance my case? Generally, if you've spoken at length to your witness previously or know what they're likely to say, if you think they were shut off in cross-examination about a point and you have a fair idea that they have something useful to add, then fine. But don't let a bad situation become worse because you've allowed amplification of a bad answer. It might be you're just digging a deeper hole. So just think about it. You can never guarantee a thing, but you use your best judgment. So the way, I'll give you a process for those of you who aren't so familiar with how to do it. And this is just the way I do it. It's no special magic to it. But I say, in cross-examination, you're asked about X. And what that does immediately is get your opponent to keep sitting down instead of objecting. This wasn't raised in cross-examination. So you're telling them, in cross-examination, you're asked about X. In answer to the question, blah, 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 you said this, and you tell them what their answer was. You've taken them right back. They're very comfortable that they know what you're talking about. Now, and then you say, well, what I say, now my question to you is this. And then you give the question that you've thought about that flows from that question in cross-examination. They feel that they know where they are, and hopefully they give you an answer that's going to assist the case. Tender is also an area that people often stumble across. You have a document to tender. Well, to start with, it needs to be only tendered through a witness that's somehow familiar with it. If not, you can't put your tendered document through that witness, or you can't tender the document through that witness. So it's important that you establish that the witness knows about that document. And so you will say, Mr. Green, can you look at this document, please? So the document's taken to Mr. Green, and Mr. Green looks at the document. Do you recognise that document? Yes, he says, I recognise that document. Okay, what is it? And he describes the document for me. Seems pretty right. He's identified it. And I tender that document. I don't ask for permission from the court. I tender it. You have the right to do that. So not, may I tender, or I'd like to. I tender that. It's really simple. So first thing, you get it handed to them. Don't tell them what it is first, otherwise you're mucking up the process. You've got to establish that this witness knows the document. And if you've already told them about it, well, it's less able to be established in that way. So you get the document to them. They say whether they recognise it or not. They identify it. It gets tendered, and probably the words of the witness in describing it will be used in some way for the tender. Okay. We've got about 10 minutes left, I think. So we've talked about how you address the tribunal and the court. It's really, really important, the next one. This is under the title, the heading, Respect and Dignity and Professionalism. Don't cut off the witness, and don't cut off the judge. You've got to know which side your bread is buttered on, and it's not going to be assisted by cutting off the judge. Even if they're saying things that you don't like, don't be discourteous. Doesn't mean you have to accept it, doesn't mean you can't challenge it, but do it professionally. You don't do anybody any favours by ranting and raving. You don't get anywhere, in my experience, by having a hissy fit, being churlish, being rude. All it does is give you a bad reputation, and as we know, from all of you will already know, the law is a very small world, and it travels gossip like wildfire. So at all levels, when you're on your feet, the spotlight is on you, and in this case, the camera's on me. So you're very conscious of your words. You don't want to start swearing. We've all seen transcript where there's the occasional word in here, there, where somebody's gone off the rails. It doesn't help your reputation at all, and once your reputation is tarnished, it seems to be tarnished forever. So be very precious about it as an advocate, and do guard that very, very carefully. We talked about courage, and it's really, really important to challenge a witness where necessary on vital points, and it does take courage sometimes. Sometimes you have very cocky witnesses, people who are very sure about themselves, They might see me as diminutive. They might say, well, you know, I'm this, that and the other. They need to get a very different impression. It's not about puffing out your chest and headbutting the witness, but it's about taking a sensible approach, sussing out that witness first. As remember, we sussed out the tribunal member earlier. We're going to suss out the witness. We do that hopefully before they take the witness box by talking to your own people about them, getting a sense of what they're like, perhaps reading their statement very carefully many times, their affidavit if there's one, any material that relates to that. It might even be you've done a Google search on them, but you're getting informed about how they are and how they operate, because that will inform your cross-examination. And your cross-examination is going to be not just what you've prepared, but also on a lot of gut instinct. It's what you do in normal conversation when you meet somebody. Someone seems a bit arrogant, you might step back a bit and observe. See where it's coming from. See what they act like if they get pushed a little bit. But don't just take one approach. It's not a one-size-fits-all equation here when you are dealing with cross-examination. You see many barristers, advocates generally, you see many people just take the same approach day in, day out to every witness. Well, in my view, that's a real wasted opportunity. It may be somebody on the other side, as a witness, is going to give you absolutely everything you need without having to be at all harsh with them, without having to develop an aggressive stance or tone. And it's about working out what to do about that. It might be that you've got a witness that you know you're going to have to tackle some difficult issues with. You might choose to leave those till a bit later in the cross-examination so you get the good stuff out first easily, develop that rapport. There's many, many tricks that barristers employ. One of them, with a witness, is to work the silence. So, you ask a question, I ask a question in cross-examination, Victor gives me his answer, and I just hold it and I wait there. And I might raise an eyebrow, keep him suspended. Most witnesses find silence very, very uncomfortable. And I'm holding it because I'm quite happy in this zone, and suddenly starts blah, blah, blah. And off it goes. And it might be that there's a point that you pick up and then work on. Now, these are the sorts of things that barristers use all the time. And it's important to be aware of this. It's important to think about whether you're going to use that if you're in cross-examination. Consistency is very important. Your professionalism, it may be that you're well known to the court, the tribunal, the particular person on the bench, but also consistency in your case. Once you've decided the approach you're going to take, you don't want to be here, there and everywhere. Hopefully you don't take a shotgun or scattergun approach and pull out every possible point. Select your better ones, and hopefully you've got a couple of decent ones in there, approaches you can take, and stick to those, or even better, most times, stick to one. And make sure it's consistent throughout your whole approach. It's not that you're just asking questions for the sake of it of witnesses, you're being selective. And every question you ask should have a purpose. Don't just ask it because you can. Don't just ask a whole lot in cross-examination because you think your client feels like they're getting better value for money. You can undo a case very easily that way. Have a purpose to all the questions that you ask, whether it's examination in chief, cross-examination or re-examination, and be mindful. You might have a lot of questions written down. It might be that you realise as you're working through this witness that that's no longer actually important. Something else is. Keep alert and keep working it. It is a work in progress. It's not a finite thing. Nothing's predictable in court. Expect the unexpected, and really you should. And if you don't, then you're missing out on a lot of opportunities. We've spoken quite a bit about being yourself, so I'll jump that point. Dressing appropriately, well, I think most of you attended pretty well to that today, and I don't think we need to talk too much about that. But don't just dress in a way that you think is going to be acceptable. Dress in a way that you feel that you can also be confident. So if you're a bit shorter and want to feel a bit taller, it might be that you don't wear flats. but you have some heel. If you have clothes that are too restrictive, you're not going to be able to gesture freely. You're not going to feel comfortable. You'll be distracted. Make sure that you're not too hot, too cold. It's harder for blokes, I've got to say. You're in court and it's a stinking hot day. The air conditioning's gone in the room and you really have to either wait or ask permission of the judge to remove your suit jacket. But think about this at the start of the day. It does make a big difference. And feel professional. Feel like you're confident in what you're wearing. Don't wear your worst shirt, something you don't feel so good about. All these things help get you in the right zone. Opening submissions, just quickly. Keep it simple, stupid. That's the first one, the KISS one there. You don't want to sing chapter and verse. Do capture the imagination. Give it some colour and movement, but don't go crazy. Be brief. Perhaps introduce your witnesses. Make sure you don't set the expectations so high that you can't possibly meet that unless everything goes swimmingly. And that doesn't usually happen, that everything absolutely goes your whole way the whole time through a case. Closing submissions, build your framework up for the court, and why you're doing that is think about when you're presenting your submissions that you're effectively writing the judgment. And even better if you hand it up in writing, and even better if you send a copy electronically, if that's permitted by the court, to them, and you might find great slabs of those written submissions that you've so carefully crafted appearing in the judgment. The judgment might only add a few words here and there if you're lucky. And I can tell you that judges love that in the main. They might pick and choose, they mightn't credit you with a whole lot, and even better if they think it's their own. Gorgeous. Anticipate questions from the bench or points that the other side are going to make when you make your submissions. Don't avoid the difficult stuff. Otherwise, you're making it too easy for the other side. Well, they didn't even address this point, Your Honour, and the reason that obviously blah, 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 and away they go. We've talked about the beauty of using simple words, so it's also helping people understand, but it can be much more effective sometimes. Yes, Your Honour, they had as a result of that collision, they got a hematoma. That might go over the head of many people. Not necessarily those in the room, but as a result of that collision, Your Honour, they had a really deep, nasty, black and purple bruise. It lasted for 6 months. Okay, perhaps that creates a different impression. But you're there for effect and understanding. We've spoken about witnesses a little bit, and in the last dying seconds before we count down and we're about to be invaded, I believe some bar readers are using this room shortly. A good witness, to wrap it up, is a fair witness, somebody who doesn't just go in hard and is inflexible and immovable, that they accept reasonable concepts. A bad witness, therefore, is one that doesn't. They lock in and they won't budge, even with reasonable suggestions. It's a bit grey out there today, isn't it? You say to the witness. No. Can you see out that window? Yes. The sky's grey, isn't it? It's blue. You know, how reliable is that witness going to be across all of their evidence if they don't accept reasonable things put to them? We've spoken about preparation a little bit with witnesses. We've spoken about body language. Think about the order of your witnesses, the natural way that the story comes through to the listener, being the judge or the jury, so they can get to understand all the issues that you need to explain. The choice of experts, how they come into it, qualify them so you're setting them up as the expert before you launch in and have to explain that later. But this guy was really important, Your Honour, is an associate professor or whatever he is or she is. If you leave it till later, not so good. You want to get it in first as you're introducing them, their name, their professional address, etc., and then their qualifications, any appointments that they have, these sorts of things. Don't forget how important the visual is and exploit it with maps, photographs, video footage, whatever you've got. A little object here, an exhibit, etc. So make sure all the necessary parts of the story come out in chief. Take complete control in cross-examination. Don't forget about the rule in Brown and Dunn. Most of you, if not all of you, ought to be quite familiar with that, but effectively in one sentence you're just putting your instructions to a witness if there's conflict in the evidence that they give. Listen, listen, listen to the answer. Don't, in cross-examination, think that this is a place to make submissions. Keep that for your closing submissions. We've spoken about tender. We've spoken about watching the judge. Last couple of points here. And last thought, perhaps, as we wrap up, is be courageous, but be mindful. Don't be foolhardy. I hope you've got something out of today's session. Thank you so much for coming along. I'm glad that the sun is at least trying to force its way through the clouds, and I hope you all have a terrific day. Thank you.